Good afternoon, everyone. Thank you so much for joining us today. My name is Denise Keele. I am the Executive Director of the Michigan Climate Action Network. I will serve as the moderator for today's press conference. We are recording and live streaming this event, and we'll take questions at the end from the media. First, I would like to recognize the tens of thousands of Michiganders from all walks of life who have stood together for over a decade, showing up at events and rallies and sending comment after comment to a slew of different regulators and elected officials with a repeated and unified message to shut down Line 5 and no oil tunnel. Back in March, at oral argument, our attorneys asked the Michigan Supreme Court to reverse the Michigan Public Service Commission's flawed decision to approve a permit for Enbridge to build a tunnel for its Line 5 oil pipeline across the Straits of Mackinac. On Friday, at the close of their term, the Michigan Supreme Court handed down a stunning victory for tribes, environmental advocates, and everyday people who've joined hands in the fight to stop the dangerous Line 5 tunnel project. The decision reverts the case back to the Michigan Public Service Commission for a more thorough review of the Great Lakes public trust protections and the tunnel's impact on Michiganders and the environment as required by the landmark Michigan Environmental Protection Act. This case is so important for so many folks, and for us at the Michigan Climate Action Network, it truly is because it just defies common sense to invest in a fossil fuel pipeline that endangers our greatest freshwater resource amid rising global temperatures. We are in this fight to ensure that we at least recognize the reality of climate change and fully consider the likely impacts from increased greenhouse gas emissions. Remarkably, those impacts were not fully analyzed, nor were alternatives to the tunnel fully considered. Our perspective is that alternatives do exist. Not only are there other pipelines Enbridge could use to at least keep their dangerous product out of the Straits of Mackinac, but moreover, the reality is that we are moving away from fossil fuels and there are renewable energy sources at the ready. Michigan is a leader advancing 100% clean energy by 2040, and this decision is a huge win for us as we now have a chance to stop new fossil fuel infrastructure and avoid nearly 30 million tons of carbon emissions annually, or the equivalent of 19 million gas-powered passenger vehicles every year. Climate change is affecting us all right now. Remember the wildfires from just a couple weeks ago, and disproportionately ravaging the natural resources, economic livelihoods, and safety of the tribal nations located in Michigan, the very same communities bearing the unacceptable risks posed by the existing Line 5 pipeline and the proposed tunnel project. So even more importantly, this decision not only acknowledges climate change, but the voices of sovereign tribal nations, whose way of life, sacred sites, and ancestors will now have a chance to be protected. We stand as allies with our tribal partners as we live to fight another day and stop this risky and unnecessary tunnel. We are grateful to the Michigan Supreme Court for recognizing that the tunnel project requires rigorous environmental review and for the opportunity to show that the tunnel is not a safer option, especially as Michigan leads the way toward a clean energy future. 4 tribes, including the Bay Mills Indian community, along with the Michigan Climate Action Network and Environmental Law and Policy Center, challenged the permit before the Michigan Supreme Court, arguing the Michigan Public Service Commission incorrectly limited the scope of its review and assessment under the Michigan Environmental Protection Act. Here with us today to discuss those arguments are President Whitney Gravelle of the Bay Mills Indian community, Adam Ratchenski, a senior attorney at Earthjustice, Chad Hughes, senior attorney at Environmental Law and Policy Center, representing its members and the Michigan Climate Action Network. And in a separate appeal, our co-appellants, Flow Water Advocates, argued that the Michigan Public Service Commission should have rejected the tunnel under common law public trust doctrine. Here with us today to discuss that argument is Riyaz Kanji, representing Flow Water Advocates. Thank you all so much for being here today. That is also the order of our speakers. First up, President Gravelle, it is truly my honor to welcome you to speak and maybe even celebrate today.
Thank you so much, Denise. I stand before everyone today with gratitude. For generations, our people have understood something that the law is really only now beginning to recognize that the Great Lakes are not a resource to be managed. They are a sacred relative to be protected. The Great Lakes are the source of our food, our ceremonies, our economies, our identity, and our treaty rights. Our ancestors made decisions with these waters in mind 7 generations before us, and today we are continued to be called upon to do the same. Last Friday, the Michigan Supreme Court delivered a landmark decision that reaffirmed an important principle. When decisions affect the Great Lakes, you cannot look at only one piece of the puzzle. You must consider the full impacts to our waters, to the public trust, and to the generations who depend upon them, including those of tribal nations. For too long, Enbridge has attempted to narrow the conversation. They wanted the question to only be about a 4 mile tunnel beneath the Straits of Mackinac, but the tunnel has always been a trap. It invites people to focus on those 4 miles of dangerous and untested concrete beneath the straits while ignoring the hundreds of miles the pipeline itself is meant to keep operating. Our tribal nations have always said that that was never the real question. The real question before us is what extending the life of Line 5 means for the Great Lakes, for treaty protected fishing, for our homelands, and for every community that depends on clean water. And the court agreed. The court agreed that the Public Service Commission cannot ignore those questions. It held that Michigan's Environmental Protection Act requires full evaluation of whether this project extends the operational life of Line 5, whether less harmful alternatives exist, they do, and critically, what this project means for the public trust, the state's legal obligation to protect the waters of the Great Lakes, and the public's right to fish, hunt, navigate, and use them. For tribal nations, this is especially significant because while the court discussed the public trust as doctrine under Michigan law, we know as tribes that our relationship with these waters predates the state itself. Our treaty rights are not theoretical, they are lived every single day by our treaty fishers, our harvesters, our families, and our communities. And protecting the Great Lakes means protecting the promises made to our tribal nations. This decision is a victory, but it's also not the end of the fight. As you said, and as we understand, it sends this permit back to the Michigan Public Service Commission with very clear instructions to do the job the law requires, to look at the real impacts of the project, the cumulative impacts, and to consider the alternatives while honoring the public trust. And as tribal nations, we intend to make sure this happens. We will continue standing together because we know that our knowledge, our science, our voices, and our treaty rights must be brought forward. Because protecting these waters is simply not an environmental issue, it is an obligation to those who came before us and those yet unborn. We must protect the Great Lakes for all generations. Thank you.
Thank you so much, President Gravelle. We'll turn things over to Senior Attorney at Earthjustice, Adam Ratchenski.
Thanks, Denise, and thanks, President Gravelle. I don't have too much to add to those great remarks, but I do want to take a minute to explain and celebrate what is the most positive and consequential MIPA decision from the Michigan Supreme Court in many decades. First, I want to highlight that the court's decision corrects an injustice. The commission, at Enbridge's behest and the urging of its own staff, tied the hands of tribal nations at the outset of this case. It did so by barring them from presenting evidence about oil spill risks and impacts to critical treaty-protected resources, including fisheries. And those resources are the fabric of their being. And the impacts are not hypothetical. This aging pipeline has already spilled more than 30 times, and this misguided project would subject tribal nations and Michiganders to 99 more years of risk and pollution. The tunnel is a 4-mile Band-Aid on a 640-some-mile problem. The commission twisted itself in illogical knots when it approved this project, and we've long said that their analysis wasn't just illogical, but it was a violation of MIPA's core requirement to determine a project's polluting effects and properly assess the alternatives to a project. We're thrilled that the court agreed with us. This decision sets forth a well-reasoned and clear MIPA framework for all Michigan agencies, one that does not allow for willful blindness or ignoring entire categories of pollution from a project. And I want to be very clear that this is not a case where an agency looked at 95% of the issues and the court said, just go back and do the other 5%. The court rejected the commission's framework of analysis and sent this back to the drawing board. It didn't say go back and do a little more. It said go back and do it right this time. And we'll be fighting every step of the way to make sure that happens. The case sets a precedent that will result in better protection for Michigan's air, water, and natural resources, and critically for the communities and creatures that rely upon them. That's a great thing for everybody, and we should celebrate it. And now I'll pass it over to a fantastic partner in this fight, Chad Hughes, who is an attorney with the Environmental Law and Policy Center.
Thanks so much, Adam. So I'm going to spend just a few minutes discussing probably the most legalistic holding from the court's decision. The court did a lot of things, and I think most practically looking forward, what's next in this case, going back to the commission, it's going to be what Adam just discussed. The scope of review was too narrow, and we got to go back and start over and do the analysis under the Michigan Environmental Protection Act again. And then there's another practical consideration that my colleague Riyaz Kanji is going to discuss next, which is about this whole discussion of the public trust and the commission's failure to do an analysis under the public trust doctrine and whether there's impairment of public trust. But there was this other issue about the standard of review. What are the proper standard of review? What is the proper standard of review for evaluating agency MIPA determinations? And MIPA is the Michigan Environmental Protection Act. So we originally brought our MIPA claim before the commission, and the commission denied our claim, and we appealed. And when we got to the Court of Appeals, there was this issue of, okay, well, how is the Court of Appeals to evaluate the agency's determinations made under the Michigan Environmental Protection Act? And Enbridge, interestingly enough, actually agreed with us that the courts are really supposed to take a really independent look and do a searching review of the record below, and they're not to defer to agency MIPA determinations. But the Court of Appeals said that yes, in many instances, the standard of review is this sort of independent searching review, but not in this case. In this case, we're to defer to the agency, and so the court in effect said, and I'm paraphrasing here, like, hey, we might not necessarily agree with everything the commission did, but we defer to them as the agency experts. So we appealed, and that appeal, reached the Michigan Supreme Court. And we argued that this kind of deferential review to the agency on these really, really important matters under the Michigan Environmental Protection Act is inconsistent with the text and the purpose of the act. And the court agreed with us. The courts, when reviewing these agency determinations, have to do an independent and searching review. They cannot defer on these really important issues. And so the bottom line here is that this makes the act more forceful, more substantive, and less formalistic. And that's great news for people who care about environmental protection in the state of Michigan. So now I'll pass it over to Riyaz Kanji of Kanji and Katzen, who represented Flow Water Advocates in this case and argued the public trust issues.
Thank you, Chad. Thank you, Denise and Mike Han and everyone who's here today. I think we are here to celebrate and commemorate the Michigan Supreme Court has issued a clear, forceful opinion that I think will have significant implications, not only for the critical fight over the future of Line 5, but for Michigan citizens and generations to come. I think it is appropriate at the outset to express appreciation to the court, to Justice Welch for a very clear, well-reasoned opinion on behalf of the court. It is also appropriate to express appreciation for the tremendous coalition that has worked so hard on every aspect of Line 5 for many years, including this fight over the tunnel, a coalition, and this is dear to my heart, that combines tribes and environmental groups, that combines attorneys and advocates, and not to be underestimated, as Denise said, the power of Michigan citizens. I will never forget the image at the Michigan Supreme Court argument and the press conference afterwards of the hundreds of people who came in from all over the state, young and old, from far and wide, in what was a tremendous demonstration of the importance of these Line 5 issues. That's an image that I know I personally will carry forward with me in this work as such a concrete reminder of what is at stake here. The Michigan Supreme Court, as President Gravelle and Adam and Chad have so ably discussed, had two key pillars to its holding, and both are extremely important, not only for Line 5, but for shaping Michigan law going forward. The Michigan Environmental Protection Act is an incredibly powerful statute as it was written. It was meant to empower anyone in this state to sue anybody for acts that degrade our natural resources and our public trust. The Michigan Supreme Court's opinion reaffirms the promise of that statute, the vitality of that statute, and it is a statute that can and should be used as a tool to protect our precious resources, not only for us, but our children, our grandchildren, the generations to come. And we owe them no less. And this decision reaffirms the central role that the statute can play in that fight. The public trust doctrine dates back to Roman times. It is a doctrine that the Michigan Supreme Court has consistently reaffirmed as a bedrock principle in Michigan law. And it stands for a very simple premise, which is that the waters and bedlands of our lakes, our precious lakes and rivers and streams, are not for the use of private corporations or individuals. Those are held in trust for the public. All of us have a permanent, fundamental, abiding interest in those resources, and they are meant to be used and devoted with the public trust firmly in mind. The court reaffirmed that promise as well. So what does this mean going forward in terms of the fight over the tunnel? As the Supreme Court noted, the Public Service Commission did not have the benefit of its opinion as a roadmap. It shouldn't have needed it, but it now has that very clear roadmap. Under that roadmap, if the commission follows it, the tunnel should not be green lighted again. And leaving aside the legal intricacies, that is fundamentally because the law at its best reflects common sense. I think common sense tells us that boring fossil fuel infrastructure under the heart of the Great Lakes to lock in that infrastructure for another 100 years does not accord with common sense, and it does not accord with the promise of MIPA or the public trust. But what I most want to say is this: we could continue this fight for another 5, 10 years between the courts and the agencies, and litigate that to conclusion. But we shouldn't. It is time for Enbridge to give up the ghost of this tunnel. There are people at that company who want to do the right thing. I know that in my heart. And it is time for all of us to come together and set aside this fantasy of a tunnel, which has acted as nothing more than a fig leaf that has allowed the existing pipelines to continue in operation. We can, as Denise said so well at the outset, come up with solutions that allow for the economy to continue to thrive while protecting what is so dear and precious and irreplaceable for all of us. In my personal view, those solutions should include a far greater emphasis on renewable energy sources. They can and they should. But even if we were hell-bent for whatever reason on replicating the flow of every single drop of oil to Canada for Canadian purposes, we could do that. But there are ways now for Michigan's leaders, policymakers, citizens, and Enbridge itself to come together and forge once and for all a solution that puts our Great Lakes out of risk. I think we can all safely and reasonably say that future generations, our grandchildren, our great grandchildren, will not look back and say, thank God they kept Line 5 in operation. They will look back, I hope, I dearly hope, and say, thank God they came up with a solution and put an end to it and safeguarded our futures. We owe them nothing less. Thank you all very much.
Thank you so much, President Gravelle, Adam, Chad, Riyaz, your leadership, your hard work, and everyone here recognizes that it's our generation's turn to stand in the breach. We are standing on the shoulders of ancestors and of environmental giants in our own Michigan Constitution from 1963. It's our turn and to make our future folks proud. And I'm so grateful to work alongside everybody here. I'll now open it up to questions from the media. You saw this in the chat. Please raise your hand, or you can put your question and name in the chat. And before asking, I would ask that you cite your specific news outlet and, if possible, which of the speakers you would like to try to respond to your question. And I will do my very best here, folks, with names and pieces. Looks like up first with their hand is Bloomberg. Eric Heisig, please proceed with your question.
Thank you for getting my last name right. I appreciate that. Eric Heisig with Bloomberg Law. This question is for anybody who wants to answer it, actually. I wanted to see if one of you, or more than one of you, could talk about Governor Whitmer's stated desire to shut down the segment of Line 5 through the Straits, while her administration and regulators she appointed approved a project that would extend the pipeline's lifespan.
I'm going to always hand the first request to President Gravelle when those are open. President Gravelle, your statements on this have been very clear. Would you like to say something?
Thank you, Denise. I think that question actually speaks to what I identified in my opening remarks, is that the state has really been caught in a trap that is the conversation around the tunnel project. Enbridge has put us between horrible and horrible, which is that we have to deal with the contemplations of the tunnel project while also being forced to live with the current conditions of the Line 5 dual pipelines. And everyone agrees that as they currently are, that is not something we want to allow to continue to exist in the Great Lakes. But what Enbridge is prohibiting and in many instances preventing is a conversation about Line 5 altogether. And we're all in agreement that Line 5 should be decommissioned because it's not something that, if permitted now, would be allowed to put the Great Lakes and such a large freshwater resource at risk. And so I do believe that the state has been caught in that trap. You know, on one hand, there's litigation taking place for the full decommission of Line 5. And on the other hand, the state is attempting to permit the Great Lakes Tunnel Project, and that comes from the political pressures that exist in this conversation, the misinformation that has led the public into believing Line 5 is an essential energy infrastructure for the state of Michigan when it is not. And so in all parts of our conversation and litigation, we have been peeling back the layers and showing folks the truth, which is that Line 5 is not only not necessary to the state, but is not part of our future.
Mm-hmm. Would other colleagues, Riyaz, Adam, anyone else like to say anything about that?
I'll just add one quick thing, which is this. We spent over a year under President Gravelle's leadership in a tribal consultation with Eagle over the question of whether Eagle would issue permits for the tunnel under the leadership of Director Phil Roos at Eagle. That was the most robust, informed tribal consultation that I've ever been involved in, and I'm an old man. And I believe in my heart of hearts that the decision that Eagle ultimately made was not the decision that the agency left to its own devices would have made. That was not the tenor of our discussions. That is not where the law or the science pointed. I think, Eric, that enterprising reporters like you and others might direct that very good question at the governor and the governor's office and ask a lot of questions about the political considerations and pressures that may well have informed that decision.
Thanks for that, Riyaz and President Gravelle. I don't see our other speakers. Maybe
Denise, if I could just add one bit
go
on
ahead.
top of that. I mean, I think, Eric, you're picking up on a theme here, and that's been a long-running theme with the state government, particularly under Whitmer's leadership. It was certainly the case when this stuff was first proposed, and in 2021, 2020, Whitmer's agencies approved a set of permits for this tunnel project. And as you just saw last month, another one of her appointed agency heads approved another permit for this project. We think they're misguided and wrong. I don't know if that's a political calculation going into those decisions, but it's been a constant theme of support, at least in terms of actions rather than words, from Whitmer's state agencies.
Mhm. Thanks for that, Adam. Next on with their hand raised is Kyle Davidson from Michigan Advance. What's your question, Kyle?
Hey, all good to see you again. I would just wanted to kind of touch on the previous permits that were approved earlier this month, last month, time is a soup. I wanted to see, kind of what we were looking at as far as the environmental review that was conducted as part of those permits versus what we are going to now be seeing again under the MPSC. What's sort of the difference as what's being looked there, between the Eagle permits versus what environmental issues is this going to touch on and encompass in, the new MPSC review here?
Got it. I could take a stab at that. I'm going to let our lawyers take that one first. Our great lawyers at Environmental Law and Policy Center. Would Chad want to maybe talk a little bit about what we're expecting the MPSC to now have to review?
Sure. Yeah. I mean, in terms of the difference between this latest permit that was approved, more recently, I mean, I think that was a much more limited review than what we're going to see before the commission. And Adam, I think, probably will want to say a little more about this, but as he said, there's going to be a very extensive review going back to the commission, and at a minimum, and although it's going to be more than this, at a minimum, this key question of what's the impact of the tunnels of the tunnel on the operational life of Line 5 is something that is going to be at issue in this proceeding that has not been at issue in any other proceeding before now.
And I want to add, a key difference with it being remanded now is 641 miles.
Mm.
That is something that was not considered by the Michigan Public Service Commission previously. That will now be placed before them. And that was a really frustrating part of the previous proceedings, as well as in all the conversations that we had with state and federal agencies, because everyone said, what if there's an anchor strike? What if, it ruptures in the straits? Yes, that would be devastating, but what no one was willing to consider is that Line 5 has already spilled over 1.3 million gallons of product in the Great Lakes, and that it spills in other places than the straits. And with the way our waters are interconnected, the way our wetlands hug one another, how fisheries and spawning grounds and tributaries all rely on one another, that answer was really unacceptable. And so the key difference is 641 miles must now also be taken into consideration by the Michigan Public Service Commission.
Mhm. Adam, do you want to respond to that too?
Yeah, I can add a little bit more. It's a great question, Kyle, and I think it can be a little bit difficult to tell just on the basis of how Eagle reaches its decision. Obviously, the Part 303 and 325 permits called for an examination of the wetland impacts under Part 303, and that's the wetlands that Eagle deems to be in its jurisdiction, as well as Part 325 impacts to the Great Lakes bottomlands. Now, how that's interpreted can mean a lot of different things for a tunnel. It appears based on Eagle's decision documents, which are not extensive, that included the placement of temporary structures on the bottomlands for water intake and discharge due to construction, and then a little bit maybe of foreseeable impacts from tunneling, but it's explicitly not covering the actual big thing here, the tunneling underneath the state-owned bottomlands and through them. And so what exactly Eagle reviewed and took into consideration of this decision. It's hard to tell based on those decision documents, but if it's anything like last time Eagle approved this permit, it is as narrow as possible, despite public comments that were submitted and lots of stuff touched on through conversations with the agency, touching on much broader range and more significant range of environmental impacts.
Great. Thanks, everyone. I don't see any of our other participants who want to do that. I'll move on to the next from Politico, Carlos Anchondo. Carlos, go ahead with your question, and if it's designed for anyone.
Hi, thanks, Denise. I wanted to ask, firstly, Enbridge has said that it's reviewing its legal options after the decision from the Michigan Supreme Court. So I wanted to ask, what are those from y'all's perspective? And then two, more broadly, what is the current strategy or plan to shut down the existing Line 5? Because it's still operating. So what is that strategy from you all right now? And then I guess if there's a follow-up, I did want to ask if you all are pushing candidates, including Jocelyn Benson and their campaigns, for details on how they would approach Line 5 and the proposed tunnel. It seems like there is sometimes a difference between how candidates approach the existing Line 5 and the tunnel project. So it's just curious. I know that's a couple questions, but thanks.
That's okay. I'll field the latter one a little bit first. The Michigan Climate Action Network has invited the gubernatorial candidates to speak with us at several occasions, and unfortunately, scheduling conflicts have not allowed that to happen. We like to have those conversations in transparent public venues, and so that has proven very difficult to do this election season at that level. What we're looking for in the next governor is what are their appointments to these agency heads, the Michigan Public Service Commission and Environment, Great Lakes and Energy. What are those going to look like? Will they be a governor who supports this enforcement of the Michigan Environmental Protection Act and the public trust doctrine? And will they continue the easement revocation and that whole set of litigation, as well as support the new Attorney General in continuing their litigation to stop this? So I think that's kind of briefly what we'd be looking for in the next gubernatorial candidate. And maybe Riyaz or one of the other lawyers would like to take the first attempt at your other question, which is also great, around what is Enbridge? What do we think Enbridge does now? And how do we focus and return on, again, every day the dual pipelines are still a ticking time bomb, and those need to be shut down, in our opinion, while and until and if we decide on what the next thing we're supposed to do is. But I'm sure some of the other folks, that was a great question around Enbridge and the alternatives and pieces. Does some of the teams want to pick that up?
Yeah, I can take that, Denise. On the existing legal options for Enbridge, one critically important thing, which I'm sure everyone understands about the Michigan Supreme Court opinion, is that it was based on core state law doctrines, MIPA and the public trust, which means that Enbridge could try to take this decision up to the U.S. Supreme Court, but they would have no basis for doing so, and it'd be just a waste of time and energy. These are quintessential Michigan legal issues, and the Michigan Supreme Court has the final word, which means that the next step would be the remand to the agency, to the Public Service Commission. And as I said at the outset, we could have an awful lot of fighting and elongated proceedings there, or we could have an attempt to actually come together and work out a solution once and for all. And I think we can all hope for the latter, but we will prepare for the former. In terms of the fight over the existing pipeline, there is currently a very important case in front of the United States Court of Appeals for the Sixth Circuit, which is the Court of Appeal, the Federal Court of Appeals that covers Michigan, where Enbridge has challenged the actions of the state in terminating the existing pipeline easement and terminating and revoking that easement. Enbridge has challenged it. That decision is preempted under federal law, both by the 1977 Pipeline Treaty and by the Pipeline Safety Act. The state has one more brief to write in that case. Then there will be oral argument and a decision. A point I really want to emphasize is that in terms of thinking about the existing pipeline fight, Enbridge is making all these arguments that the state can't enforce its rights with respect to the easement. The original easement in 1953 contained a lot of conditions to protect the interests of the state and the citizens, and also was subject to the overriding protection of the public trust doctrine. Enbridge wants to argue that all of that is overridden by these federal laws that it's pointing to, but the company is being too clever by half, because if they're right and federal law preempts those protections, what that means is that half the bargain that the state agreed to is swept off the table. And under core, and this again is state law, if you lose half the bargain, the whole bargain goes away. In other words, the state can't be held to an agreement where it can't enforce its side of the bargain. And I think Enbridge has consistently overlooked what is a very basic legal principle, and that ultimately, and again, this could be worked out sooner, it could take a few years, but common sense and the law coincide, and either the state is able to enforce the conditions on the existing pipeline, or the whole agreement goes away. In either case, the existing pipeline should cease to operate.
Thank you, Riyaz. Chad or Adam, would you like to make further comment on the legal avenues ahead of us with Enbridge?
I would just add one quick thing, and Denise, you mentioned this, but just to make clear, there's also this other case that's pending in the circuit court in Michigan, the AG's case. So you've got two fights right now. One, and that AG case actually brings Michigan Environmental Protection Act case. So it's going to be impacted by this decision, and the circuit court will be guided by Justice Welch's decision in this case.
Great. Looks like next hand up is Sheldon Krause. Would you please state your outlet and your question and who it is for?
Hey there, Sheldon Krause with 9 and 10 News here. Thanks so much, everyone, for being here. Appreciate it. And just kind of for whoever might have some perspective on this, just wondering if there's any estimate for, how much of how long this new review process might take. Of course, keeping in mind that there could be some kind of settlement or agreement sort of reached before that. But maybe just some context on how long this previous review took, and kind of thoughts on how long this new process might potentially take.
Yeah, I can start with that one, Sheldon. I would anticipate that there will be a new hearing before the Michigan Public Service Commission sometime in 2027. There's some sort of procedural steps that need to happen before that, where we'll gather back before the commission and set a schedule for discovery and development of testimony, which I would expect to take place this fall and through the winter. And so it's hard to pinpoint exactly when, but I would suspect that sometime in 2027, there'll be a trial-like hearing before the commission, and then some months after that, an additional decision.
I'd just like to make sure that we frame this appropriately to, every year of remand is a year that Enbridge is choosing to pursue an unlawful shortcut. And really the only way to end the risk now is a shutdown. So that's still high on our minds, and it's Enbridge who has been delaying a good decision in these proceedings. The next hand that I see up is Lisa RC from Mirrors. Lisa, go ahead with your question, and if it's for anybody.
Good afternoon. Thank you. I actually have a couple questions, but I'll ask them one at a time if you don't mind. I think the first one is probably better suited to the attorneys. What, if anything, new information-wise do you hope to present to the Public Service Commission as it prepares its new evaluation?
Good question, Lisa. I know Chad's ready for that for our side. Who wants to go first?
I'll defer to Adam if that's okay.
Mhm.
Sure, that is a good question, Lisa, and I won't tip our hand to everything that we hope to maybe present, but there's some of it that's outlined in the court's decision, including, the actual lifespan of the dual pipelines that will be replaced here, which I think as the court sort of hints at, is only 8 years. Then it's clear that this tunnel project extends the life of this pipeline by, 99 minus 8 years, or however long they want to make that calculation. So some of that, which brings in all of the oil spills along Line 5's water crossings, right? It's not just the straight segment that's in bad shape. It crosses hundreds of waterways along its route, many of them interconnected with the Great Lakes, and a spill at any of those crossings would have devastating effects to the Great Lakes and tribal fisheries. I think it's important to remember for that the Kalamazoo spill, as it's commonly called, did not spill into the Kalamazoo River. It spilled into a tributary and caused devastation downstream. And so when you think about all these water crossings that are very near to the Great Lakes that it crosses along its path, that type of evidence, that type of risk is very, very real. And we've seen it not only from a pipeline in Michigan, but a pipeline owned by the same company in Michigan. So that's, I think, sort of front and center and something we presented to the court and the agency beforehand that we want to present, which is not necessarily new information, but a new information that we were not able to present before. And there's a whole host of other issues that we'll be developing through testimony and experts.
Okay. If I may, my second question is also better suited to the attorneys. Are you aware of the recent filing from the U.S. government in the Enbridge case in the federal court? And if so, what's your reaction? Do you know which case I'm talking about? Enbridge versus Whitmer?
Yeah, Riyaz, do you want to grab that one? You may be better suited to speak on it.
Sure. Yes, that's in the Sixth Circuit proceeding. It's of a piece from what we've seen from the federal government. The brief essentially argues that under the Pipeline Safety Act, the Federal Pipeline Safety Agency governs has exclusive authority to the exclusion of the states. I think it's a legal position that is extremely ill-advised, both legally and as a practical matter. And just to focus on the practicalities for 1 second, the Pipeline Safety Agency is a highly ineffective agency. It has proven over and over again its inability to regulate pipeline safety in advance. Some of the most notorious pipeline releases that we've had in this country, including the Kalamazoo River spill, all came under PHMSA's watch. And so we feel very strongly, and the state of Michigan feels very strongly, Attorney General Nessel's been a leader on this, that we cannot leave the future of our waters in the hands of an agency that has proved to be so ineffective. And if I can just return to your first question for 1 second, and it was a great question too. The other point that the point that the court made very clear is that every agency in the state is charged with public trust considerations in its decision making. The commission did not engage with those considerations the first time around. Two central ones that should be of importance to every Michigan citizen: navigation and the fisheries. The fisheries are reeling lake trout, whitefish. The Mackinac Straits are iconic spawning grounds. The fact of boring a tunnel and all the industrial activity that would go along with it for 6, 7, 8 years will have extremely detrimental effects on both the fisheries and on navigation, the right of every Michigan citizen to boat in that area. So those are considerations that we will hope to bring to the fore in addition to the critical ones that Adam mentioned.
Thank you. I do have one more question, if I may, and I think this one is perhaps better suited to Ms. Gravelle. No disrespect, but there are some people who may think this issue doesn't touch them because they're not directly, maybe they don't use the Great Lakes, maybe they don't see its importance. It's just not something that they might consider or think about on a regular basis. And I know you've spoken before about how it affects everyone. Can you address for those people who think that this issue doesn't touch them, why they should care and why they should be concerned?
For Bay Mills Indian community, a large part of this conversation has also been educating people about the relationships that we maintain with both the land and the water. And so for somebody that might be in Lansing or Mount Pleasant or Detroit, and you can't physically see the Great Lakes or you're not enjoying the Great Lakes on a daily basis, you still maintain a relationship with them. Not only are they responsible for clean drinking water for nearly 40 million people across the Midwest, but they are very integral to our climate, to our seasonality that we have here in the state, to the temperatures and the wildfires and the climate change that we're all experiencing in terms of impacts due to fossil fuel infrastructure across the United States. And so, even though it may not seem like there's a direct impact, the Great Lakes as a freshwater resource is something that gives us life and will continue to give us life and provide for our livelihoods moving forward. On the other hand, something that actually isn't necessary and seems to be, considered critical or sort of like a doomsday scenario if it doesn't exist is line 5, which is misinformation. And so that's also been part of our conversation is, why are we delving into the misinformation around line 5? People fear that it's going to skyrocket fuel prices. Enbridge's own experts in court under testimony, under oath, state that if Line 5 shuts down, it'll impact fuel prices by less than a penny. They say that 60% of the Upper Peninsula's propane is needed because of Line 5. As a propane user myself in the rural Upper Peninsula, it's not true. And many people forget that Line 5 shut down for almost 90 days before and nobody noticed. Nobody noticed. Your home was still heated. You were still able to drive. Gas prices didn't skyrocket, and you could still cook food and put it on the table at home. Nobody noticed. But if the Great Lakes dried up and disappeared the next day and we could no longer use them and have that relationship with them, it would harm millions and millions of people. And that's just me speaking from like a factual and like a scientific perspective. My people, we have our own teachings about the Great Lakes. For us, it is the center of creation for North America. It is the heart of Turtle Island. It is something that will continue to provide for us. And that is because in our teachings, we understand that man and woman were created last, not because we are the most important, but because we are the least important. And so we rely on all that which came before us to be able to survive. And what is the first thing in creation in many stories and in many religions across the world? Water. It all starts with a flood. It all starts with water. And that is because water gives you life.
That's
Thank you
right.
so much.
Thank you, President Gravelle. Thank you, Lisa, for those questions. I would add just one more piece to your question about those impacts. As I said at the top of my remarks, Michigan Climate Action Network and represented by Environmental Law and Policy Center seeks to recognize the reality of climate change. Those impacts were never fully considered. And as all the speakers have stated, neither were any of the alternatives to this disastrous, risky project in the worst place possible. And those climate impacts, as President Gravelle indicated, are already impacting every single one of us. And there is a better future that Michigan is already on path towards. Looks like a couple more questions here. Mina Fuqua of WLNS. Go ahead with your question and who it's for.
Hi, yes, thanks for having me. I am Mina, and I do have a question for President Gravelle. I want to just ask maybe two questions here. So, what does the recent ruling mean for the tribal treaty rights, and what would you like to see happen next?
Yeah, so, seeing the most recent ruling sort of adopt the position of the tribes and the consideration of the public trust doctrine for me was very significant because I see the public trust doctrine as the sister to tribal treaty rights. They are both inherent and placed in a situation where you're acknowledging relationships and resources and what those means for future use. And so a lot of people think of treaty rights as something historic or something that might be old. They think of parchment paper. They might think of like the founding of the United States. but they are living exchanges. And when you think of a treaty right, you also have to think of not just the physical act of fishing, but that you need clean water for fish to spawn, and that you need a clean environment to be able to hunt, and that you can't have pollution to go out and gather. And so the treaty right does not exist without the protection and maintenance of the public resource, which is really encapsulated in the public trust doctrine itself. And so we really see those as sister doctrines to one another. And, speaking more from like a broader view is treaties are often also associated with the federal government, with our treaty trust responsibility and relationship with the United States. We know that treaties are the supreme law of the land, and that is what maintains our relationship. But the public trust doctrine and its foundation in common law here in the state of Michigan also raises it to a level of supremacy, that the state is acting in a fiduciary responsibility to maintain those resources. And so when you pair those together, you have really strong foundational law about maintaining resources for their future use for future generations. And one item that our attorney Adam from Earthjustice had touched on as well is the tribes had attempted to raise all of this before the Michigan Public Service Commission. There was testimony and expert reports highlighting the tribal treaty rights and the impacts that the projects would have on the treaty resources. And time again, those were ignored and they were not considered because it was not part of their scope of review. But it is, because when you maintain the public trust, you also maintain the tribal treaty right and you maintain the treaty trust responsibility that we have with the United States. It applies to the entire country and every decision maker and how it impacts tribal treaty resources. And so for me, when we look at those together, it was a really, truly meaningful decision last Friday, not only for tribes, but also for every citizen in the Great Lakes.
Well said. Thank you so much. I also have one for the attorneys. So the Supreme Court's decision, I know there was a permit previously overturned. Why was that overturned? And does this stop the project permanently, or does this delay the project?
Mina, I'm not sure about the first question, referring to a prior overturning permit. We did challenge the Eagle permit in 2021, and that eventually reached an agreement with Enbridge and the state agency that that permit would not be used because it was set to expire before the tunnel would be built. So that resolved our challenge. But this is not, I want to be careful with this delay framing. This is not a delay. That sort of assumes that eventually you get to approval, but this is really a reset of the analysis and a true evaluation of both this project and its alternatives under a new and forceful MIPA framework that frankly the commission just did not do before. So the framing of this as, oh, it's a delay and then in 2028 we just get it, I think is buying Enbridge's sort of talking points, and it's not in line with the realities of the situation, that this is really starting from scratch and will maybe result in an entirely different outcome.
Thank you for clarifying that. So what happens next procedurally?
Yeah, I touched on this before. So procedurally, we will have a hearing at some point for the Michigan Public Service Commission, just a scheduling hearing to set forth timelines for discovery where interveners get to seek information from Enbridge. Enbridge gets to do the same. Everyone develops their expert testimony to put it forth before the commission. And then sometime after that, there will be a hearing, which is a trial-like hearing where the witnesses go on the stand before an administrative law judge to build the record. And then the commission will read that record and issue a new decision on the permit, which was vacated. It was overturned.
Thanks, Mina, for your questions. Again, I would just reiterate that everyone on this call today was trying to present that exact kind of evidence that would have resulted in a rigorous review, and we were unable to do so. So we want that rigorous review. That is always what we have tried to do, and we're finally getting that opportunity. And so it's Enbridge who has delayed that review to do that right and to finish this. Looks like one more hand is raised. Colin Jackson, Michigan Public. Go ahead with your question.
Yeah, thanks for taking my question. I'm wondering, given this wide interpretation of the public trust doctrine, does this make it easier to fight the Eagle and DNR decisions last month? What implications does this have for fighting those, especially since those decisions were already made before this came out?
Yes.
Another good one for the lawyers.
Yeah, I can. Thanks,
Thank-
Colin. I can take it. Great question. Yes, it absolutely does make it easier. It reinforces the strength of the challenges because the court made it so crystal clear what should have been apparent to the agencies in any event, but made it crystal clear that every agency decision needs to be imbued with a proper consideration of the public trust. The decisions last month that you are referring to did not engage in public trust analysis. And that analysis is it's very important and meaningful, but it can be distilled very easily to the proposition that any use of public trust resources, and the bedlands of the straits are a quintessential public trust resource, any use of those must advance public trust purposes. In other words, the public's interest in the fisheries, in navigation, and in other public trust uses. If they don't advance those uses, or if they are, or if the proposed use is anathema to those uses, the uses cannot be blessed under the doctrine. And that is not an analysis that either Eagle, the DNR, or the Public Service Commission have ever engaged in with respect to the tunnel, and it's what they will be required to engage in now in robust fashion.
Great, thanks. Everyone has had one go around, so Kyle, I'm happy to take another question from Michigan Advance. Go ahead.
Hey, I'll just kind of bounce off Colin's question. I know in previous discussion that I had with Earthjustice, I know they mentioned that a appeal of the Eagle permit, as DNR permit, was on the table. So while we've got all the attorneys here, I was kind of wondering, is anyone looking at a challenge? Has there been any sort of appeal filed there? I guess, not to jump to a completely other separate set of permits, but is there anything expected or anything on the table as far as a challenge there yet?
Kyle, good question. I can say still on the table, not yet filed. You haven't missed anything. And I think I'll leave it at that for now.
There will be challenges filed. There are 60 days to file challenges from the date of the Eagle draft decision, and I think it's safe to say there will be challenges filed, and the exact configurations are being worked on.
Thank you all.
Great. Well, I know that all of us, one more? Is that Taylor?
Oh, sorry.
Taylor? That's
Gay-
okay. Go ahead. Yeah.
I'm with the Energy Mix in Canada, and I just have a question which may seem silly, but I've been doing a bit of reading, and I was wondering if one of the lawyers could distinguish between public interest and public trust, because my understanding is that Line 5 generally has been declared in the public interest. I'm wondering if there's a distinction.
Yes, great question. Nice to have somebody from Canada on, and thank you for the great work that Energy Mix does. You're absolutely right that sometimes people use the phrase public interest broadly and have used that to justify, bless the operation of Line 5 and other pipelines. A lot of the what Enbridge likes to point to is that in 1953, the determination was made that Line 5 was in the public interest and hence was approved to cross the straits. That was in 1953. And whatever one might think of that decision at the time, and there are lots of reasons to question it, we know an awful lot more now than we did then about the risks of crude oil and climate change and everything that we have learned the hard way. So even that public interest determination is subject to great skepticism and question, but they are different doctrines. The public trust, as I mentioned earlier, is specific to public trust resources like the waters and the bedlands. And again, the question that is asked under the public trust analysis is simply whether the devotion of those uses to private concerns advances public trust interests in navigation, in the fisheries, in other core public trust uses. You don't, for example, factor in, well, is burning crude oil, is that good for the economy? That is not a public trust analysis or assessment. It goes to the use of the public trust resources, and that is the determination that has not been made that the Michigan Supreme Court called for.
Thank you.
And I want to build on something Riyaz just said too, because when Line 5 was built in 1953, the voices of tribal nations and tribal consultation were not conducted. And so for tribes, for more than 70 years, we have lived under the shadow of Line 5. And every single day, we've carried the knowledge that one rupture could forever change the waters that define who we are. We cannot be Anishinaabe without the Great Lakes. It's just simply not possible. And so this decision finally gives us something that we haven't had in decades, that we haven't had in 70 years, which is the possibility of a future where that shadow is lifted and where the Great Lakes are no longer held hostage, because finally tribal voices are being included in the conversation.
Thank you.
Thanks, everyone. Our own Michigan Constitution is predated by Enbridge. Enbridge 1953 leaves our Michigan Constitution of 1963. I'm gonna end with reading it because it's so powerful to me. These are our own environmental movement ancestors that worked hard to pass this, that now we're upholding too. Michigan Constitution of 1963, Article 4, Section 52, the conservation, development, and natural resources of the state are hereby declared to be of paramount public concern in the interest of the health, safety, and general welfare of the people. The legislature shall provide for the protection of the air, water, and other natural resources of the state from pollution, impairment, and destruction. Again, the public trust doctrine predates all of that. The Michigan Environmental Protection Act is based on that constitutional principle. We are all standing in the breach of a long line of folks protecting our environment and people. And we're so glad that everyone could come today and celebrate for once a true victory that recognizes those principles. And we look forward to working with the agencies in all the processes ahead to provide that evidence and rigorous review that should have started at the very beginning. So thanks everyone for joining us today. I don't see any more hands in there. If any of our speakers, I would invite you, any closing remarks that any of you would like to add. Maybe you didn't get to respond to something, no pressure. If anyone likes to just add anything else, now's the time. I think we're going to leave it at that, folks. Again, thank you all so much for your time and attention to this important matter and to a huge win that gives us another day to fight. Thanks, everybody.